This is section 17.
Do you want to move the amendment?
I move it.
Move the amendment.
Thank you. Reasonable caps on damages awarded in defamation actions before the High Court. Now, I will start by saying something very simple. Justice should be fair, proportionate and predictable. That's not a radical idea. That's the foundation of any functioning legal system. When it comes to defamation laws in Ireland, we are falling short of that standard. At present, there is no statutory cap on general damages in the High Court defamation cases. That means a jury or a judge can award any amount they see fit with very little guidance, and we've seen the consequences of that. We've seen awards that are widely inconsistent, sometimes eye-wateringly high and often completely disproportionate to the actual harm suffered. So let me give a hypothetical example. Imagine a well-known figure sues a local blogger for defamation. The blogger has a modest following, no legal team and limited resources. That case goes to court and the plaintiff is awarded $500,000 in damages, more than the blogger could earn in a decade. That is not justice, that's a financial annihilation. And let's be honest, these kinds of awards don't just punish the defendant, they force most people to ask themselves whether they want to speak out. Is it really worth the risk? And when the risk, even a remote risk, is potentially six figures, the answer is invariably no. That's the chilling effect we keep talking about, and that's why this amendment seeks to address. So under Amendment 10B, I propose that general damages, those for injury to reputation and so on, be capped at $250,000, and that the total award, including aggravated and exemplary damages, be capped at $400,000. These are still substantial figures. They still allow for meaningful redress, but they also introduce clarity, consistency and restraint. Importantly, this amendment does not cap special damages, those that represent actual financial loss. If someone can prove they've lost income, contracts or opportunities because of a defamatory statement, they can still be fully compensated. That's fair and that is just. And to ensure flexibility, the amendment allows the Minister to adjust these caps over time with reference to inflation and broader legal trends. So we're not locking ourselves into a fixed figure forever, we're simply setting a reasonable benchmark. Now, I know some will argue that this interferes with judicial discretion, but I would ask, is it really discretion when there are no boundaries? Is it really justice when cases can result in widely different awards? Other areas of law, personal industries, for example, have caps and guidelines. So why should defamation be an exception? We must also consider the broader impact on our courts. Excessive awards encourages more litigation, they incentivise speculative claims and they undermine public confidence in the fairness of our laws. They also clog up our already overburdened system. In fact, we have to very seriously consider the fact that Ireland has become a prime destination for defamation tourism. Wealthy international figures and corporations deliberately look for ways to ensure that they can take their defamation cases in Ireland, furthering and distorting our legal systems and case laws. So this amendment is not about protecting defendants at the expense of plaintiffs. It's about restoring balance, predictability and stability. It's about ensuring that defamation laws serve its true purpose, to vindicate reputations, not to destroy lives. So I urge on my colleagues to support this amendment. Let us bring defamation laws in line with best practice. Let us ensure that damages are fair, proportionate and rooted in reality.